House Bill 1. Representative Lang. Mr. Clerk, read the bill.
House Bill 1, a bill for an act concerning alternative treatment for serious diseases causing chronic pain and debilitating conditions. Third reading this House bill.
Representative Lang.
Thank you, Mr. Speaker. Ladies and gentlemen, we've been talking about this for some time, not just this year, but for the last 4 years. Before I proceed, I wish to thank the advocates, some of whom are in the gallery. I wish to thank a whole bunch of people, including Senator Hayne, who sat around a table for a very long time to try to make this the best bill in the country. I believe we have done that. The title of this bill is the compassionate use of medical cannabis. I would like you in this chamber to focus on the word compassionate rather than on the word cannabis. That's not working. This bill is the most controlled and highly regulated bill ever drafted, ever written in the United States of America. 20 other states and the District of Columbia allow for the use of medical marijuana to provide a higher quality of life for very sick individuals, some of whom are dying, some of whom are not, but have medical conditions that require the use of this product for their quality of life. We took the mistakes that other states made and fixed those mistakes. So someone on this floor might say, well, they made a mess of it in California, Representative. And you know what? They did. They had a very loose piece of legislation, and pretty much anybody in California who has a doctor willing to sign a piece of paper for whatever reason can get their hands on medical marijuana. And of course, it's been abused in California. We have fixed that mistake. We have done so by requiring many things. First, a patient must have a bona fide relationship with a physician licensed in the state of Illinois. The physician must certify that the patient has one of 33 specifically named medical conditions in the statute. So if you don't have a bona fide medical condition, or if you don't have one of those listed in the statute, you ain't getting the product. And to prove this, you then need to take the physician's recommendation and all of your medical records, proving this disease or medical condition to the Department of Public Health, who's going to pore over those records and make sure you have that bona fide relationship and make sure you have that disease. That patient, along with their caregiver, is going to have a background check, and most of them will be fingerprinted. And none of them that don't pass muster will get the product. And so if they're a felon, or if they have a drug offense that they've been convicted of, they're not getting the product. This background check goes for not just the patients and the caregivers, but the growers and the dispensaries, whether it be the owners or whether it be every employee working in those facilities. Every purchase made is limited, and every purchase made goes into a database that's accessible not only by every dispensary, but everyone in law enforcement in the state of Illinois, so that they know who's buying, they know what they're buying, and they know where it's going. This bill has reflected the concerns of law enforcement, although truth be told, not all law enforcement is for the bill. But I will say many in law enforcement appreciate the work that we've done and have gone neutral on the bill. The bill deals with DUI issues in a very strong way. Today, if you're taking OxyContin for your colon cancer and you drive and a policeman stops you because he thinks or she thinks that you've been driving recklessly and maybe are under the influence of something, they can't make you take a field sobriety test. This bill requires every medical marijuana patient who's stopped to provide implied consent to a field sobriety test. And just as in an alcohol situation, if you don't walk the line or you don't take the field sobriety test, you lose your license to drive. That is not the test for any other drugs in the state of Illinois, any other issue, any other pharmaceutical, just marijuana if this bill were to pass. The bill provides strong rules to allow employers to make whatever rules and regulations they wish to make on the job site. If they say no marijuana here, there's no marijuana there. The same for landlords. Landlords can say to a tenant, you can live here, but you can't use that stuff in my building. The bill also provides that local communities can create whatever zoning they need to make sure that dispensaries are moved to wherever they want them within the community. They can't zone them out because that would be discriminatory against very sick people. But they can decide where in their communities they want them to be. This bill provides strong rulemaking authority to the Department of Public Health, the Department of Agriculture, the Department of Financial and Professional Regulation. These rules were these provisions in the bill creating strong rulemaking was written with the governor's office, who support this rulemaking. As I said before, the state police are neutral on this bill, but they would tell you that they appreciate all the efforts that we have gone to try to deal with each and every issue they have had, particularly the DUI issue. Let me point out that this bill is no longer House Bill 30. It's no longer a bill we had some years ago regarding grow your own. This is not grow your own. This provides for 22 growers, and the reason we picked 22 is one for each state police district so that we don't overburden the state police with inspections. And it provides a maximum of 60 dispensaries to be scattered around the state of Illinois by some rules that the department would put together to make sure that everyone in Illinois who needs this product has access to it. Ladies and gentlemen, this is not about getting high. It's not about dope. It's not about what our mothers told us when we went to college. This is about providing a product at no expense to the taxpayers to provide better health care to people who desperately need this product. There are people in the gallery today. Many of you know Jim Champion, who's sitting way at the top in his wheelchair, a veteran with MS, who is crumpled much of the time unless he uses a little marijuana. And it's not always smoked. Sometimes it's vaporized. Sometimes it's in a cookie or brownie. But when he is able to access that product, and I hesitate to tell you how he accesses the product, it's not a pretty sight. When he accesses that product, his hands open up, his legs uncrumple, and he is able to enjoy a better quality of life. There are grannies in this state, ladies and gentlemen, with colon cancer who are terminal, who simply want to be able to enjoy their grandchildren or go to the movies or maybe even do their laundry. There are 30 and 40-year-olds who are desperately ill who want to continue to work. We had a press conference last week with a woman from Rockford. The woman from Rockford has stage 4 terminal pancreatic cancer. She is going to die. But she came here deathly ill to speak at the press conference. And what she said was that she had wasted away from about 125 pounds to about 80 pounds and couldn't eat and couldn't take care of herself. And when she started eating marijuana cookies and marijuana brownies, just like we were told when we were in college, she actually got the munchies. And she began to eat. And she gained 25 pounds. And she's able to enjoy her daughter at the park, which is all she wants to do for the rest of her life, enjoy a quality of life with her daughter. Pretend that it's your spouse, your parent, your child, your cousin, your neighbor. And their doctor says to them, you ought to be able to have this product because the Oxycontin, the Vicodin, the codeine, the morphine you're taking isn't working, or it's putting you flat on your back for days at a time and you can't do anything. And the doctor says, take this, eat that cookie, take a puff of this joint, if you want to call it that, and you can feel better. And it doesn't work for everyone, but it works for a lot of people. Ladies and gentlemen, 20 other states allow for this, and they allow for it in a way that isn't as controlled as this bill, isn't as detailed as this bill, isn't as regulated as this bill. Now, I know every single one of you has compassion in your heart. This is the day to show it. This is the day to get beyond politics. It's the day to get past elections. It's the day to talk about your constituents. I told someone earlier today when they told me that their police chief was opposed to it, I told them two things. First, the police are rarely for legalizing something that's illegal, especially involving medications. And second, there's a whole lot more sick people in your district than there are police chiefs. So, ladies and gentlemen, this is about the people in the gallery and their caregivers. This is about the people that live in our districts. This is about providing health care. The federal government spent 2 years and many billions of dollars providing Obamacare, which some of you like and some of you don't, but the bottom line is it's costing the taxpayers a big chunk of money. This is health care that won't cost us a dime. Let people feel better. Let them have a better quality of life. That's what this bill is about. I beg your aye votes.
The chair recognizes Representative Bost.
Thank you, Mr. Speaker, to the bill. Ladies and gentlemen, I don't doubt that everyone on this floor knows how they're going to vote on this one way or the other. But I have been around for a long time and listened to the debate. And let me tell you that on this floor and on the Senate floor, when we actually had members who actually served as pharmacists, they gave testimony that there are drugs that are available that can do exactly what marijuana does. Now, there are those that you might disagree with that, but they were the experts that were on this floor. Now, if we're going down this path, the concern that I have is that the former speaker says the bill automatically says that you can't ban it from your community, even if your community agrees, because, see, that would be discriminatory, but you can place them somewhere. So that supposedly makes it better. You know, I have compassion, regardless, even if I vote no, I still have compassion for those who are suffering. And to try to make that plea that if we vote no, that we don't have compassion is totally wrong. There are needs, but there are already drugs out there available according to the experts. Every state that has implemented this has had problems. And it doesn't just stay with the community that needs this as far as their own medical need. It becomes a problem. It becomes a problem on the control of a substance which has been illegal for years. Now, you can either agree with it that it should be legal or say, no, it shouldn't be legal, but don't try to piecemeal it like this. If you want to come forward with a bill and say, let's legalize it, then let's legalize it. But to do this is just going to, I believe, cause confusion in our communities. The sponsor said that, we watched California and they had problems and we corrected those type problems. Well, then the other states passed it and then they had problems and they had to correct problems. So, but every state has had problems. And ladies and gentlemen, there's no doubt I will be voting no on this piece of legislation. And that doesn't shock anybody in this room. But I am telling you that there are many problems, if this does pass, that we, the state of Illinois, will have to deal with. Mark my word. Not going to throw a fit, not going to scream and yell, but I will guarantee you that we will be back adjusting this legislation, if this is the case, with other because of the problems that will occur, or will we be back on this floor to go ahead and move for the legalization of marijuana. I'd encourage a no vote.
The chair recognizes Representative Osman.
Thank you, Mr. Speaker. Will the sponsor yield?
Indicates he will.
Representative, when you were giving the description of this, I think you omitted one part. This is a pilot program. And how long does this pilot program last for?
Thank you for asking that question. I had actually written that down because I did forget to mention that.
And you forgot it in committee, too. But
yes,
this is an important
a 4-year pilot program. And it doesn't even become effective till January of 2014. And we did that so there'd be lots of lead time to prepare. And we did that, and in the bill it allows the agencies 120 days to do rules. So it will be a very long time, at least a year, before anybody's licensed to grow or anyone's licensed to purchase, and probably a year and a half before anybody gets it in their hand. And this will give us time to make sure if there are changes, we can make those changes, if there's something we left out or something we need to adjust, and we can do it along the way as well. But 4 years from January 1st, 2014, this bill, this notion, this program will sunset unless it's renewed. And if it becomes a big mess, I won't be standing here on the floor trying to renew it. But I don't think it's not going to be a big mess. I think we're going to be proud that we did it. And the next time around, we'll have a lot more than the bare majority we're going to get today to support this.
Representative, you know that I've been here for a little while, and I can remember that I think it was my first year that you brought this bill forth, and there's been many, many times that I've asked you different things to be fixed and adjusted. One was grow your own. I couldn't support that. And you did do those things. You tightened this every time you came back and tightened it more and tightened it more. Not to be disrespectful to the previous speaker, but I believe that this is something that can be worked in and done properly. And if it isn't, I'll be looking for you in 4 years, because I am going to support this. And the reason I'm going to support this is because I've had one personal, where I had a friend come and live with me. He and his wife came for 2 solid years. He suffered with terminal cancer. I would not let him have marijuana in the house. I don't know if he got marijuana. I just know that the Oxycontin made him extremely sick, very sick. And my dear friend Ralph died 2 years ago. He never asked, only once, if he could have marijuana in the house, and I said no. Sometimes I resent that because I knew that it might have helped him. Last summer, I was called by a constituent who asked me to come to his home. I went to his home, and I saw firsthand what phantom pain is. Phantom pain, for those who don't know, is when you've lost your limbs. In his case, the 2 legs were amputated. He was in a wheelchair. His wife was there, and a caregiver was there. This man was in constant pain, and he told me the only time that he has relief from that pain is if he sends his wife out to purchase marijuana illegally and for him to have it in a brownie or some other way. But that's the only time that he feels that he can function. He can get up and actually know where he is, because the drugs that he was on just made his head not function right. He was always in a daze because of the Oxycontin he was on. I understand very well that there are people here in this chamber that can't vote for this. But I want to stand up and tell you that this is the right thing to do, because I feel that we do need compassion for these people that are suffering so hard. I saw it firsthand, and I'm really, really asking you to consider a 4-year pilot program. We do tons of pilot programs. Please, please consider giving a little compassion to those who are suffering so much. Thank you.
The chair recognizes Representative Tryon.
Thank you, Mr. Speaker. To the bill.
Bill.
Every time this bill has come before this body, I have rose in opposition to it. Today I'm prepared to support it. But I want to tell you why that is. I think each of us have had constituents come to our office and give us constituent testimonials that are very hard to deny the benefits that they're receiving from the use of cannabis. The same individual who lost their legs in Representative Osmond's office has a minister who's a friend of his in my district. I visited with him. There was no drug that worked for his phantom leg pain. The only thing that worked for his pain was the use of cannabis. That was very convincing. But more so than that, other constituents that came forth and told me the effects that they were able to get were good. And if they could get it, why should they have to obtain it illegally? Why should they have to enter into a culture to obtain it that is illegal? And I agree with that. But more importantly, 4 years ago, I did an end-of-session newsletter that I put into 36,000 newspapers. I got 500 responses back. 75% of those who responded were in favor of the use of cannabis for medical purposes. I did it again a second year. Got the same result. This year, out of 3,000 on my email list, I did a survey, an electronic survey. I received 20% back, got a 72% response in favor of it. So I look at this issue now as an issue that if I have constituent testimonials that are very convincing, I have a voting public in support of it, I have now the obligation to make sure we have a law that is strict and provides only access to those who would be qualified. And I think this law does this. This law means that you have to get your diagnosis from a physician that you've had an ongoing relationship for the past year. You have to only go to a few dispensaries to be able to obtain it. Limited number of uses and illnesses and diagnoses that it can be used for. I asked my own physician if they would use this as a means of treatment, and they said yes. And that was the final thing that made me and convinced me to vote for this. My own physician said she does not prescribe narcotics. She does not prescribe Oxycontin, Vicodin, or any narcotic. But she did have patients that would benefit from this, and it would be something she would recommend. I look at this as an issue that is still under our state rights. We sometimes forget that it wasn't the federal government that created the states. It was the states that created the federal government. We have on the Department of Justice website, it says if a person in a state who has a state-provided provision for medical use of cannabis, it says they won't enforce that current law on those individuals. It is an option, I think, somebody who can benefit from it should be able to receive that benefit. And they shouldn't have to enter into a culture of corruption to obtain it. They should be able to get it and use it within the boundaries of our law. I commend the sponsor on continuing to work for it, putting forth the strictest medical cannabis law in the country, and one that I think goes far enough to make sure that it gets in the hands of those only who are going to receive benefit from it. And I'm going to vote yes. Thank you.
The chair recognizes Representative Zaleski.
Thank you, Mr. Speaker. Will the sponsor yield?
He indicates he will.
Representative, you gave a lengthy open on your bill, and while it was substantive, part of the piece that I think we need to be fleshed out a little bit, given the importance of it, is the effect that the bill will have on our driving under the influence of substance law. So indulge me for some questions about that piece of the bill. Isn't it a fact that under your bill, and if you have a possession of the card, of the ability to do this, for all intents and purposes, if you get behind the wheel of a car and there's an incident where you're pulled over, you're guilty of driving under the influence of a controlled substance, correct?
Well, you certainly could be. And so anyone that gets one of these cards and is able to purchase medical cannabis is going to be registered with the Secretary of State. And of course, if you're in an accident, one of the first things the police officer is going to do is check your driving record and check if you own the car, etc. He or she will see that you're a medical cannabis patient. If the officer thinks you're impaired, there's an implied consent that you must do a field sobriety test. This isn't the case with any other narcotic that people are taking today. Oxycontin, Vicodin, morphine, codeine. You could be under the influence of those, and you could be driving under the influence legally or illegally, but the officer cannot make you take a field sobriety test. We have taken this a step further, even though cannabis is not as dangerous, it's not addictive like those other narcotics. You can't OD from it, and yet we've taken the step to make sure that the members of this body, the members of the general public, and law enforcement is all understands that we're very serious about passing a controlled piece of legislation. And so these folks will have to submit to a field sobriety test or lose their license.
So, Representative, are you aware of a case in DuPage County, People versus McPeak?
Why don't you tell me more about it?
Okay, so in People versus McPeak, from what I'm told, you had an incident where a driver had smoked cannabis. They had gotten behind the wheel of a car. The officer made observations that the driver smelled like cannabis. The officer observed cannabis in the car and observed a smoking device. Representative, take a guess at what happened in People versus McPeak.
Well, since you raised the issue, I'm going to assume the case was dismissed.
Well, the person was ultimately found not guilty by a court. Your bill, in fact, fixes that incident because, isn't that correct, Representative?
It in fact does, because first of all, you can't drive with cannabis visible in the vehicle. It has to be in a tamper-proof, apparent container. You cannot smoke in your car even if you're just a passenger. You can't use marijuana even if you're just a passenger. And indeed, if the officer thinks that you're driving under the influence, you will have to take the field sobriety test.
And in fact, by allowing an officer to administer field sobriety tests, we're making a change in the statute that actually will result in more individuals potentially being arrested for driving under the influence of alcohol or under the influence of a controlled substance when in the past they haven't been culpable. Isn't that accurate?
That is accurate. It actually cleans up a problem with the current statute. In the process of dealing with the medical cannabis bill, we had to dig deeper into this statute, and so we ended up repairing something that needed to be fixed.
So thank you, Representative. To the bill, I've in the past, similar to other speakers, have voted no on this particular piece of legislation. But in my judgment, if we can address a glaring problem in the vehicle code when it comes to driving under the influence of intoxicating substances, and we can do it within the context of providing more safety for our roads and protecting people from hazards by allowing field sobriety tests, which are a deterrent from people for driving under the influence of intoxicating compounds, then we should do it. There may not be things that we all can agree on, but we can agree on public safety. And the gentleman has a pilot program. I think people are crying out for help, and I think that we're doing things to address the public policy in Illinois in a positive, good way that protects the public safety. I urge an aye vote.
The chair recognizes David Harris.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, all bills that we pass in this House start with the phrase, "Be it enacted by the people of the state of Illinois represented in the General Assembly." Now, we pass hundreds of bills in this House year after year, and very few of them, though, really get the attention of the people of the state of Illinois. Very few of them really make what I would call a societal change. Certainly this year, I think same-sex marriage would fall into that category, perhaps gambling. And I think this bill is one of those bills that really makes a societal change. Now, we heard the sponsor describe the provisions of the bill, and it is a very detailed bill. And because of his encouragement, I went out and I did indeed read the whole thing. And we know that states like California and Colorado have medical marijuana bills on their statutes, or medical marijuana statutes on their books, that for all practical purposes are a joke. Of course, Oregon citizens passed a referendum authorizing recreational use of marijuana. So I think it's fair to ask, how does House Bill 1 stack up against the legislation in some of the other states? Let's look at some of the requirements of House Bill 1. What about growing marijuana? Unlike in other states, we're not talking about growing marijuana in the backyard or down in the basement. It has to be grown in one of 22 cultivation centers spread around the state. And how are those cultivation centers regulated? Complete information on the principals and board members involved in those cultivation centers, including a full background check. Every employee has to have a state-issued ID visible at all times, which contains a specific alphanumeric code. All the bylaws and procedures of that cultivation center related to plant monitoring, plant tracking, all record keeping, and the security plan for that cultivation center has to be filed with the department. And they are subject to random inspections 24/7. What about the dispensing organizations? Are we talking about some potheads with fly-by-night storefronts? Not at all. We're talking about organizations that, again, all principals and board members, full background checks, ID cards, and, again, subject to inspection 24/7. What about the patients? In other states, patients can claim almost any real or imagined physical ailment. Under House Bill 1, a patient has to be what's known as a qualifying patient. Well, what's a qualifying patient? Guess what? Full background checks, fingerprinting, issued a secure registry ID card. They must suffer from one of the specific lists of physical conditions listed in this legislation. And they lose their registry card if they give the marijuana or let someone else use the marijuana. Okay? What about the physicians? In other states, quack docs looking to make a quick buck can write a script to virtually anyone. Under House Bill 1, there must be an established patient-physician relationship as defined by the Civil Administrative Code. An examination has to take place, and that examination has to be in person, not done via some sort of remote or telemedicine means. There has to be exact record keeping by the physician. The physician cannot have any direct interest in, be on the board of, or be an employee of a cultivation center or a dispensing organization. What about transporting the marijuana? As the sponsor said, it has to be in a secured, sealed, tamper-evident container. It has to be inaccessible if it's in a moving vehicle. And the restrictions in House Bill 1 go on and on. For example, the marijuana cannot be used in an established public place or in a place in which the public can be expected to show up. We talked about why. The legislation allows a field sobriety test administered in the event of any evidence of impairment, and a refusal to take the test results in an automatic revocation of the license and, of course, loss of the registry card. There's a marijuana tax of 7%. We're not looking necessarily just about the revenue, but that 7% still allows the local municipalities to assess any taxes that they might want to impose. So you say, okay, this is going to be done and we're going to collect a lot of political contributions from this. Guess what? No political contributions are allowed to be made by any cultivating center organization or dispensing center organization or a political action committee of a cultivation center or a dispensing organization. The sponsor said, this is a model for the nation. You know, we drafted a bill dealing with hydraulic fracturing or fracking, which we, I think, rightly called a model for the nation. I think the sponsor is right here. This legislation is a model for the nation. The product is tightly controlled from seed to sale. The objective of this bill is medicinal and not in any way recreational. I was at a breakfast this morning sponsored by the Leukemia and Lymphoma Society, and at that breakfast there was an oncology nurse from Memorial Hospital here in Springfield. And we talked about this bill. I said it looked like it was going to come up today. And she looked at me and she said, I hope you will vote for this bill because I have patients that the only way that they can get relief from their pain and suffering and the many pills that they take and the nausea and all the other difficulties that they suffer from being a cancer patient is if they're allowed the use of this product. Like others, I compliment the sponsor on what he has done. This is a 4-year pilot program. We can retract it in 4 years if it's not working. He's done an absolutely great job. I firmly believe the legislation deserves your support.
The chair recognizes Representative Cassidy.
Thank you, Mr. Speaker. To the bill, I stand in strong support of this legislation. I think the sponsor has done an amazing job of crafting a truly quality piece of legislation that will stand as a model for our country, but most importantly, will bring real and needed relief to people who desperately, desperately need it. I have more people in my life than I can count who have been waiting in agony for this opportunity, and so I am grateful to the sponsor and everyone who's worked on it that we are here at this place today. I have a brother-in-law that would not be with us if not for for making use of cannabis. He has terminal cancer. The pain drugs were sucking the life out of him, and he now enjoys a great quality of life with my sister, and they are able to enjoy what will be his last days, and he's able to have a positive experience, and my sister and my brother-in-law, who I love dearly, are able to make the best of an absolutely horrific situation as a result of this product, and I urge you all to please, as the representative said, hold the compassion part in your heart and vote yes.
The chair recognizes Representative Fine.
To the bill. I want to read you a list. Vicodin, Oxycontin, Methadone, Norco, Percocet, and morphine patches. These are all drugs that have been prescribed to my husband, who's an amputee. Some he's tried, others he won't, because they are extremely addicting and the side effects are terrible. He will wait until the absolute last minute in order to take something to find some relief. And we know when he does finally take something, he's out for the rest of the day due to the side effects of these drugs. It is so heartbreaking to see someone you love to go through such debilitating pain when there can be a solution to that pain. This would be a non-addictive, non-narcotic way to really find relief for these patients. And not only would it benefit the patients, but as we've heard from so many people who've seen people suffering, it would really benefit the families who have to watch their loved ones suffer. So I really encourage your support for this bill. Thank you.
The chair recognizes Representative Sesha.
Thank you, Mr. Speaker. Will the sponsor yield?
He indicates he will.
Representative Lang, in the 11 years I've been here, this bill has been before us many times, and I concur that you have tightened it significantly. One of the questions that remains in my mind, and you alluded to and several others did, of putting the cannabis in a brownie and eating it as a type of relief. Is that a fair, did I understand you correctly, sir?
The fact is that many people don't smoke cannabis. Many people use it in food, sir.
To my point exactly, why don't we go to the FDA and create a pill that has the cannabis in it that is regulated by other medications?
Representative, first of all, the FDA doesn't appear to be interested in doing that. And secondly, there have been efforts to create pills. For instance, Marinol has been put in a pill. But Marinol is just one of hundreds of chemicals that are in cannabis. And the only way you can get relief from your pain and from your other results of your injuries or your medical conditions is to have all of those chemicals together, not just one, not just two, all of them.
At the outset, sir, you made the comment that the FDA doesn't seem to be interested, but if they are, in fact, the organization that is responsible for all of our medications, why would they not be interested?
Can't answer that, but let me tell you this, sir. The FDA approved all those narcotics that Representative Fine referred to, and each and every one of them is addictive, and each and every one of them will lay you flat on your back, and each and every one of them has led to, in this country, having more deaths by drug overdose than by traffic accident in the last 3 years.
Representative, again, I know of your strong desire to pass this legislation, and in fairness, I applaud it. I remain indifferent. I'm indifference to your point of view, and I think you know I again will be voting no. And you yourself alluded to the fact that many law enforcement agencies are against it. You noted that some are neutral. I would point out that the Illinois State Police are neutral. However, sir, they do work for the governor, and the troopers, I think, are pretty much against the bill, but they're told to be neutral, and I respect that. I understand that. The sheriffs are under no such obligation. They are opposed, and they are opposed for, you have, and again, I do believe you've tightened up the field sobriety test, but the sheriffs say it is nowhere near tight enough. And I think that in itself is a very, very significant issue. I guess where I continue to struggle with your legislation, and I have all of these years, and again, I like what Representative Boss said at the outset, that if I vote no on this, I'm still a compassionate person. I just can't get there on making marijuana legal. And again, you have brought the bill a long way. Maybe it is the perfect bill. I agree with someone who said, I think we'll see it again. And I don't think that we have really achieved what we're attempting to in order to create legislation. When I continue to struggle with the idea that the Food and Drug Administration is not interested in looking at it. I continue to struggle with cannabis, and I understand, sir, that the growers are going to be regulated, but the experience that I have had shared through my adult life is is it THC? Is that the correct product that is in cannabis?
Yes, sir.
That it can vary from one grow to another grow significantly. Is that a fair statement?
It is, sir, but we have that today. You see, today we're turning Granny into a criminal.
I get that.
Today we have turned all those people in the gallery, caregivers and people in wheelchairs, veterans, some of them, we've made them criminals. They have to go to some back alley in some town that you wouldn't want to go to in the middle of the night and get what they need to make their loved one feel better. And so, yes, there are varying degrees, but people are getting it now. In fact, we know in this room, let's not bury our heads in the sand, any high school kid in America can get their hands on marijuana. But under this bill, every ounce of marijuana that's sold will be tracked. We will know who buys it. We will know where they buy it. Law enforcement will know where they buy it. And in fact, because the growers will be regulated, they will have quality control that we don't have now.
I understand that you believe that, sir, and I'm trying to get there. I really am.
I know, sir.
But Leader Lang, you know, let's make the assumption this bill were to become law. We know there's a lot of potheads out there, folks that don't really have a medical issue. Would that be a fair statement that we could agree upon?
It is certainly true that there are people that use cannabis that should not be using it, and
You
some
said
use
that
it
so much
and
nicer
some
than I
use
did.
it to excess.
Yes, sir. We agree on that. Here's my concern. My concern is that these folks will evolve to the doctor with splitting headaches and severe back pain and all kinds of maladies.
Sir, that's not allowed in the bill. See, this is a case where, and I don't mean, I'm trying not to insult you, but this is a case.
But you're gonna.
Well, maybe. This is a case where you need to read the bill. The bill lists 33 medical conditions. It doesn't list a bad back. It doesn't list a headache. It doesn't list made-up medical issues. It lists 33 very specific medical issues. And if you do not have one of those, and you do not have a bona fide relationship with your doctor, and you do not provide all of your medical records to prove it, you are not getting the product.
Leader Lang, I absolutely believe that I could go to my doctor and go through my history of medical conditions, and I could get medical marijuana under your bill. I believe I could.
Do you have any of those medical conditions today?
I believe I do.
Then maybe you need the product, sir.
I'm doing well without it. Here's the thing, Leader, and again, you know I have the greatest respect for you, and I've watched you bring this bill a long way. I really have. But when a federal organization that is responsible for all the medications one takes in this country, responsible for all of it, doesn't even want to look at it, and law enforcement is either opposed or neutral, that speaks volumes.
Representative, the same federal organization you're talking about has approved medication that is killing people every day in this country. They're ODing, they're addicted, they're dying, they're driving, they're smashing their cars up, they're running your constituents over. The same organization and the same law enforcement people that are opposed to this bill somehow have nothing to say when the same kids that you're worried about getting a hold of Granny's marijuana are reaching into her medicine chest every day and taking their Oxycontin and their Vicodin and going to pill parties. The same kids, the same law enforcement. Now, I'm a little facetious. Of course law enforcement cares, but they aren't down here asking for a bill to do something about it.
Leader Lang, you are challenging a federal agency and basically saying in so many words that they're inept at what they do, so if they don't look at this...
Didn't say that at all, sir, because if they did the research, they would find out different. But none of the
won't they?
Because the pharmaceutical companies aren't interested in having that happen, sir. Think that one over for 30 seconds.
I don't need 30 seconds. What you're telling me is there's a conspiracy.
I'm telling you that nobody's willing to fund the research. But the pharmaceutical companies are more than willing to fund the research to sell all these products that are killing Granny.
Ladies and gentlemen, to the bill. I applaud Leader Lang for having done a great deal of work on the medical marijuana bill. I do understand his motives. I respect him as a state representative and a leader. However, this bill is absolutely a wrong piece of legislation. Listening to many of the learned representatives that have commented on this floor today, each one that I hold in the greatest esteem, I understand where they're coming from. I understand why their minds have been changed. I can't get there. And I really believe that we are making a mistake if we pass this legislation. Thank you.
The chair recognizes Representative Williams.
Thank you, Mr. Speaker. To the bill.
Bill.
I strongly support this legislation, and I've been a co-sponsor since the day I was sworn into office. But I'm not alone. This bill has also been endorsed by the Chicago Tribune, the Chicago Sun-Times, and the State Journal-Register. It's considered to be neutral by the State's Attorneys Association. So that's a law enforcement entity that doesn't often go neutral on these sorts of issues. This bill is not about the kids smoking pot behind the garage, but it's not about prescription medications. It's somewhere kind of in between. It's a plant-based option that can provide very unique benefits to people in great need. My grandma died at the age of 94. She lived a wonderful, full life, but spent the last several weeks of her life, as so many people do, in a drug-induced haze. She was gone many days before she actually passed. She was a law-abiding citizen her entire life, and it would never have occurred to her to in any way attempt to procure an illegal product, even if it meant completely being non-dependent on the fentanyl patch that she relied on to ease her pain in those last days. Sure, narcotics are very effective at pain relief, but at what cost? We talked a little bit about the side effects earlier. Obviously, these are very, very addictive drugs. In terms of the side effects, though, they are numerous and varied. They include nausea, vomiting, dry mouth, itching, shutting down your digestive system to the point that you have to take other drugs to get things moving, depression, confusion, hallucinations, bradycardia, tachycardia, severe debilitating headache, orthostatic hypotension, which I said just because I don't know what it is, ureteric spasms, muscle rigidity. The list goes on and on. Long-term therapeutic use can basically slowly shut down your immune system. Why should we deny the opportunity to people to avoid these painful side effects? Why should we provide patients who are suffering with limited options for treatment? Shouldn't we give seriously chronically ill patients every opportunity to improve their quality of life? That's what this bill is really about. It's improving the quality of life for patients that are truly in need. It's about providing safe and legal alternatives to traditional medical treatments for people at the end of the life, like my grandma, and people living with severe, chronic, debilitating illness. The unfortunate reality is that for most families, we will face someone going through this situation at some point in our lives. Wouldn't you want to provide every opportunity for your family member to get some relief? I would. That's why I'm voting yes.
The chair recognizes Representative Belloc.
Thank you very much, Mr. Speaker. Will the sponsor yield just for a few questions?
He indicates he will.
Thank you. Representative Lang, we've had quite a bit of discussion on the scheduling of this drug. So it still is an illegal substance by the FDA, correct?
That is correct.
And can a doctor prescribe this?
No.
No, because it still is an illegal drug, right?
That's correct. In the same way that pharmacies can't dispense it.
Right. So I guess in the last 4 or 6 years that we've debated this bill, and I do applaud you for how much you have worked on this bill, and I'm sensitive to all the people and the advocates who have come down and feel, that this substance really does help them. But in doing laws, as we all know, lots of times one law that can help somebody can have a ramification in a negative respect on others. And in most cases, that's where I'm coming from with drugs and kids. But in the medical groups, and in the 6 years, I think it's been that we've debated this bill, I have not seen, and I looked again today on the analysis, if another major medical group, nobody has approached me or anybody else that I know of asking them to change this. Have they come to you? Like I know there's concerns, the American Cancer Society, the MS Society, the Glaucoma Society had concerns the last time. I have not had them come to me and say lobby us for the bill, to pass the bill.
They also haven't come to me to tell me they're opposed to the bill. Who did come to me was 250 doctors that had a press conference yesterday in Chicago. 250 doctors, licensed doctors in the state of Illinois who want to be able to help their patients have a better quality of life.
Okay, I'm going to move on to a couple more things of the, when we debated the bill before, and I think it still stands, the president's drug czar going into the effect of the states that have had this legalization have seen an increase in the usage of drugs by children in the schools.
That is actually not the case. The last study I saw, and we can debate our studies, the last studies I saw showed that in 3/4 of the states where medical marijuana, medical cannabis was allowed, the incidence of children, teenagers having marijuana stayed about flat, and in several states it actually went down.
I have in Colorado, which seems to be a state, especially since they've legalized the recreational use of it, that since 2009, public school suspensions for drug violations acclaimed to the use through users have increased 45%. Expulsions for drug violations increased 35%. Statistics in the United States of children in our public schools across the United States, 1 out of every 5 children in the 12th grade is using marijuana in a week. That's 25%. Is everybody listening to that? 25% of our children in the 12th grade are using marijuana. 1 out of every 11 in the 8th grade are using marijuana. Those statistics are astonishing, and that's a concern of the ramification of this that I'm concerned about, and I know a lot of other people are too.
If I may respond,
Sure.
Every high school student in America can get their hands on marijuana, but what marijuana is it, and where did it come from? Under this bill, we will know where every gram of marijuana came from, who bought it, where it came from, how they got it, what their medical condition was that allowed them to get it, and children can get marijuana now. Having it in grandma's medicine chest isn't going to make them more likely to get it. What they're more likely to get out of grandma's medicine chest is Oxycontin and Vicodin and Norco and all these other very addictive, dangerous narcotics. And I would submit this to you, Representative. No one in the history of the world has ever been addicted to marijuana, and no one in the history of the world has ever died from an overdose of marijuana. And all of the things that you want these patients to take instead of medical cannabis are killing them and killing their children.
But marijuana is the most widely used illicit drug in the United States. That's confirmed.
I can't argue that point.
Okay. So anyways, then I wanted to just ask a couple questions about the enforcement. We had a lot of discussion, and today we've had no discussion about who is going to enforce all of this. The public health police? Who?
I'm sorry, I did not hear your question.
Who will enforce this law? You have said public health over and over again. Is that who's going to enforce this?
Representative, there's all sorts of enforcement mechanisms in this bill, as Representative Harris mentioned. First, the Department of Public Health has to ensure that the patient and the caregiver are legal and qualified patients and caregivers. So that's where it starts. Next, everyone along the way has to be licensed, background checks. No one will be able to run a facility, whether it be a grow facility or whether it be a dispensary, without background checks, fingerprints. You can't get a license if you're a felon or have been convicted of a drug charge. The state police will have and every law enforcement will have the ability to get into the database to see who's purchasing and make sure that they're not being sold more than they're allowed to buy under the law. And it goes on and on and on. The Department of Agriculture is going to have rules to regulate the growers. The Department of Financial and Professional Regulation is involved. Law enforcement is involved. Just like every other law, Representative, if you break the law, you can go to jail.
Well, break the law, you can go to the jail. This is a federal law. It's an illegal substance. It's a federal law right now.
Representative, the federal government has not arrested any grannies with colon cancer for using a product to help them to feel better. The only people the federal government has shut down are growers or dispensaries that are violating state law or have huge marijuana fields with all sorts of excess and residue that they're not properly disposing of. The federal government is not arresting any patients for taking care of their health.
I have a quote here from the U.S. Attorney Central District of Illinois saying that growing, distributing, and possessing marijuana in any capacity other than as part of a federally authorized research program is a violation of federal laws regardless of state laws addressing such activities. The Department of Justice will appropriately enforce federal laws with all of its provisions and criminal and civil remedies in all states.
The key word there, Representative, is appropriate. So I just told you that no sick patient has ever been arrested by the federal government for purchasing and using medical marijuana in states where it's legal. 0 people.
Okay. Then the last I would say is when we talked about the young people and the abuse of marijuana in the system, in a town hall meeting that I've had 2 town hall meetings in the last year and a half on heroin, all of the young people that came to testify before those town hall meetings on their own begged me not to vote for the medical marijuana bill. I know you do not believe it's a gateway drug, but every single one of them begged me not to vote for this bill. And we had 28 deaths in DuPage County last year of heroin. And those young people who have gone straight testified at that meeting and said, we know that there are people that want this drug, but there are a lot of us that feel it's a gateway drug, and we've seen our best friends die in front of us. And those are what I talked about when I started, the ramifications of sometimes passing a law that's good for a certain population, but can have other ramifications for others. Thank you.
There are 4 more people seeking recognition. We would hope that this is a very important question. Keep your marks as succinct as you possibly can. The chair recognizes Representative Hoffman.
Thank you, Mr. Speaker, ladies and gentlemen of the House. I, like many of the people who spoke before, have some concerns about the legalization of marijuana. But this isn't legalization of marijuana. It's legalization of medical marijuana or marijuana only for medical purposes. I've consistently voted no. As a former prosecutor, I told my senator, Senator Hayne, who was a proponent of this in the Senate, that previous bills I was not going to support. I've seen firsthand what drugs can do to families, what drugs can do to people who end up in the criminal justice system. But this is not legalizing marijuana broadly. It's legalizing it for very specific uses for people and family members and loved ones who are suffering every day right before our eyes. I think if many of the people who voted no on this bill in the past would not have voted no, we wouldn't have the bill as it currently exists with all of the restrictions, all the precautions, all the criteria to make sure we can do everything we can to stop abuse. People who vote yes or no on this will do it for a variety of reasons. I would say many people on this floor will vote no because they think it might lead to greater drug use. Some may vote no because politically they don't believe they can vote yes. But I don't think that there's a person on this floor who would agree that we should, if we can, do something to stop the pain, the suffering, the everyday drudgery of the people and loved ones who have these terrible and dreadful illnesses. So today, I wish that we didn't have to stand here and defend ourselves vis-a-vis other states. Those states do not have laws with these types of precautions. Those states have made mistakes. Those states' laws are too widespread and too open. And because of those states and what the abuses have occurred in those states, we have to stand and figure out whether those abuses will occur here. I think, as Representative Harris so aptly pointed out, as Representative Tryon pointed out, there are so many criteria to make sure that the illnesses are listed, that has to be prescribed by a doctor, the medication, the marijuana is going to be tracked, and even the users have to get background checks. Even the users have to get background checks. So today I'm standing and I'm going to vote in support of the bill because I believe there are the precautions in this bill to stop those types of abuses that we've seen in other states. So I'm going to vote to help relieve the pain, help relieve the suffering, so that we can give a moment of peace to these individuals, if this is the only thing that works, who are suffering this great illness and great pain.
The chair recognizes Representative Gordon Booth.
Thank you, Mr. Speaker. To the bill.
Bill.
In the past, I have not supported this piece of legislation for many of the reasons that have already been discussed, so I will be brief. Many of us come to this chamber with a set of experiences that shape how we see the world. And one of the most difficult things in this world is to watch someone that you love die in pain. The only thing more difficult than that is to watch them live their lives in pain. My office manager, her name happens to be Kami Keller-Strauss. Kami Keller-Strauss lost her daughter in August of 2011 at the age of 28 years old. Her daughter suffered from debilitating pain all of her adult life. And watching Kami deal with the death of her daughter after we took this vote, and I didn't support it, made it very difficult for me. I pledged that the next time we took this vote, that I would vote for this bill because of Kayla. I only wish she were here. Thank you.
The chair recognizes Representative Will Davis.
Thank you, Mr. Speaker. With response to yield?
Indicates he will.
Representative, I know there have been a lot of speakers, and I apologize that any of the questions that I have already been kind of asked and answered, and I apologize for any redundancy. But so when someone is given a prescription, what dictates how much medical cannabis they will be prescribed?
First, Representative, let me point out that they can't get a prescription. So you go to your doctor and he wants to give you, let's say, Vicodin, you get a prescription, he rips off the pad, you go to Walgreens or some pharmacy and you have it filled. What the doctor has to do under this bill is provide a recommendation in writing. The bill allows a patient to get a certain amount of marijuana or cannabis from a registered dispensary every 14 days. And that's what the bill allows.
So the amount that will be recommended, is it in ounces? Is it in number of cigarettes, or how is that going?
It's in ounces, and it isn't necessarily in cigarettes. And so many medical marijuana users don't smoke it ever. Many of them cook with it. Many of them vaporize it and inhale it. Those that cook with it need a lot more than those who smoke with it.
Well, but the recommendation doesn't take into consideration how an individual will ingest it.
No,
it
doesn't.
It's suggesting that this is how much they can have.
So we took what we felt was a number that mirrored what some other states are doing, talked to some people, frankly, who use the product, some experiences from other states, and came to a number.
Okay. I mean, but the bill doesn't really go into that specificity, does it?
The bill says 2.5 ounces every 14 days.
Every 14 days?
Yes.
2.5 ounces.
But the doctor could recommend less, or the doctor could say you can have the 2.5 ounces. That'd be up to the doctor.
That's 2.5 ounces is the maximum.
That's correct, sir.
Okay. So when we distinguish what we're calling medical cannabis or medical marijuana, it's just marijuana like we find grown out on fields or whatever, and sometimes in an illegal way, but it's just used for a medical purpose, right? So it's not any special type of brand or blend or, you know, and the reason I kind of ask it that way is that if anybody's ever visited California and have seen people with their prescriptions, they have very interesting names, green rhino, or, you know, all kinds of crazy names, as if to say it's different strengths, different potencies, or whatever the case may be. So we're not talking about anything like that. We're talking about marijuana as we know it, and is just being used for a medical purpose, correct?
That is correct, although I am quite certain that some of the growers will end up being specialty growers, where they will have different strains that they grow. Some might be more potent, some might be less potent, but we know this: they will be regulated, and the marijuana will be pure and clean, and is not the kind of marijuana that you might buy in a back alley someplace and you don't know where it came from.
Okay, but when you talk about potency, that could be more potent or less potent, how will a doctor know? I mean, help me to understand that timeline. So a doctor suggests that they recommend that they can have some. Now I can take that recommendation to a grower. So am I seeking out the grower that has the most potent product?
Actually,
versus...
you buy the product from the dispensary. The dispensaries buy it from the growers, and by the way, the growers pay a 7% tax to the state on everything they sell.
Okay, maybe I should have said dispensary.
Right.
And
So
not
when
a
you
grower.
go to the dispensary, you will have the choice of which product you want to buy. And yes, some may be more potent, but remember, this is not about getting high. This is about quality of life.
Well, and I appreciate you saying it's not about getting high. Obviously, for those that are recommended to buy it for their purposes, and this kind of leads into my next statement, if you will, there is possibility that this still could be abused. Because even if someone who purchases it for a medical purpose, and we don't want to take anything away from that purchase, but it is still possible that it still can be abused in some way. You know, if you have someone who is home and has a caregiver, you know, that caregiver, I mean, we've seen theft and other things happen with caregivers, unfortunately. So this could be something that could be abused in some kind of way, correct?
I suppose the caregiver could use the patient's marijuana and do whatever they want with it, but two things. First, then the patient won't have any because they're limited by how much they can buy. And secondly, I don't think we can craft laws with the assumption that people will abuse the law. And if we did that, there isn't any law we pass here that we could count on.
Fair enough, Representative. So my last issue, which may be a little different in some respects, involves possession issues. So if you'll bear with me, let me offer a scenario. So you have a prescription and I'm your friend. I give you a ride somewhere, and when I drop you off, unfortunately, you leave your pouch in my car. So I drive off, and for some unfortunate reason, I get stopped by the police. Police decide that I'm the guy whose car they want to search for whatever reason. They find your prescription with your name in you mentioned a sealed tub that it will be carried in, and they ask me what this is, and I go, it's Mr. Lang's prescription for, or not prescription, but recommendation or his product of medical marijuana. And they go, really? You sure this is not yours? I said, I can assure you it's not mine. Tell you what, why don't I arrest you for possession, and then you can prove this at some point down the road. So I go to jail, I bail out, I go to court, hire an attorney, and then you come to court and prove that it is indeed yours, not mine, and then the case gets dropped. So now I've dealt with the legal system, I've spent money to get out of jail and hire an attorney, and now the possibility that some parts or aspects of my life could be impaired because now I've got maybe a possession charge on my record that I now have to, and maybe if the court drops it, maybe it goes away. I don't know. I'm not a lawyer or a prosecutor in that respect, but it creates some scenarios that now I have to deal with. Am I wrong in any of that?
This is no different than any other scenario that we can put together. So if your friend has a legal gun and they leave their gun in your car, which doesn't even have their name on it, then the same scenario could play out. But considering that the law requires intent, I really don't think that's going to be an issue. Could some overzealous police officer go too far? I suppose so. I suppose it could happen. In the same way, if you had a friend that had any other product, gun or other pharmaceuticals or whatever, that they might accidentally have fall out of their person and leave in your car.
Okay, so in your way, this is no different than anything else. So there's no particular provision that would specifically address this. I'll just have to deal with it accordingly.
You know, that's true. And if a person left an open bottle of alcohol in your car, we would have the same scenario play out. And that happens every day. It still requires intent. It still requires that they have enough information to bring you in. And I just, while I recognize that the scenario you just put together for us is conceivable, I don't think it's likely.
Okay, thank you very much.
Thank you, sir.
The chair recognizes Representative Mell.
Thank you, Mr. Speaker and members of the House, to the bill. And
Bill.
just real quickly, I wasn't going to speak on the bill, but with all this talk and everything, I just want to say I've been taking a pain pill now for every day since August 5th as a result of some surgeries I had and some chronic pain since then. And 2 weeks ago I had a surgery, and I think it's going to correct that, and so I can get off this medication. But for a second there, or more than a second, there's a real panic that comes in because it's like I can't live with this pain, but I can't keep taking these pills. And I got to tell you, it's real and it's scary. And if we can pass this bill and we could offer some relief to people who are in chronic pain, then we should do it. And I applaud the sponsor, and I absolutely love how this body is quiet when people are speaking on an important bill like this. And I'm just really happy to see, hopefully, the passage of this bill. Thank you.
Representative Franks, for what reason would you like to be recognized? Out of the record. Representative Lang to close.
Thank you. Thank you, Mr. Speaker. Ladies and gentlemen, I appreciate the debate, those who are for, those who are against. One thing I know, this is a bill we worked very hard on, and even those of you who were prepared to oppose it today have indicated this is the best bill you've seen. We've worked very hard. I see Senator Hayne in the chamber, and I want to thank him for his efforts. And I thank all of you for putting up with a lot of conversation about this over a long period of time, but this effort has been about the patients. This effort is not about Lou Lang passing a bill. It's about the patients, providing them a quality of life. Ladies and gentlemen, in the last poll that was taken nationally, 83% of Americans from all over the country, that's the whole country, believe that people ought to be able to use medical marijuana under the direction of their doctor, 83%. And we ran some random polls in districts around the state, and in no district was it under 60%. Even some of you that are from the most conservative districts, in no district was it under 60%. Our goal here is simple, to provide a quality of life to people with a product that can't hurt them. Today, the products they're taking are hurting them. They're killing them. They're becoming addicted to them. As I said before, more deaths in this country from drug overdose than from traffic accident in the last years. And so this is a bill that is true to its title. It's about compassion. And I don't say anyone that votes no is not compassionate. Everyone on this floor has compassion. Everyone on this floor cares about their constituents and people that are ill. The question is, will we get beyond the political? Will we get beyond old theories about what cannabis is? And will we focus in on what the bill is about? Helping sick people have a quality of life, to take care of their kids, to go to work, to live some kind of life, whether they're just in pain or whether they're terminal.
And so, ladies and gentlemen, I urge in the strongest possible terms your aye vote. And one more thing before we vote. Many of you on this floor told me that you wanted to be the 60th vote. Don't do that. Don't wait. If you wait, it'll be 50 votes. But if everybody on this floor who promised me they would go green do so the instant the bell rings, this bill will pass. I beg and urge your aye votes.
Then the question is, shall House Bill 1 pass? All those in favor vote aye. All those opposed vote nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Mr. Clerk, take the record. On this question, with 61 votes voting aye, 57 voting nay, none voting present, and this bill receiving a constitutional majority is hereby declared passed. Representative McAuliffe, for what reason do you rise?
Point of personal privilege.
What's your point?
Up in the gallery from Triton College Student Association officers, we have Doris Davenport, the president-elect, Agatha Scarpelli, the secretary-elect, Lorenzo Weber, the advisor, up in the gallery visiting with the Student Advocacy Day for support of adult education. We have a big round of applause for them to the House chambers.
Welcome to the Capitol. Enjoy your day. Chair recognizes Representative Duncan. Representative Duncan, you wish to be recognized? Representative Pritchard, for what reason do you rise?
Point of personal privilege.
What's your point?
Ladies and gentlemen of the House, Representative Lang referred to some of the people in the Speaker's Gallery. I would just like to say that Sandy and Jim Champion are constituents, and we thank them for coming today and to sharing their story.
Thank you very much for coming to your Capitol. Enjoy the rest of your day. Next, for your consideration on page 6 of the calendar, we have House Bill 831, Representative Cassidy. Mr. Clerk, read the bill.
House Bill 831, a bill for an act concerning criminal law, second reading this House bill. No committee amendments. Floor amendment number 1, offered by Representative Cassidy, has been approved for consideration.
Representative Cassidy on floor amendment number 1.
If we could adopt the amendment and then debate it on third, I'd appreciate it.
Representative Cassidy, would you present the amendment?
Absolutely. The amendment to House Bill 31 represents an acknowledgement of the deadline that we are operating under to enact comprehensive concealed carry here in Illinois, and recognizes that we all represent different areas, different cultures, and different needs in our communities, and provides for an appropriate response in each of our areas to do that within a framework that I believe will be seen as constitutional.
Representative Rebelletti, for what reason you rise?
I have an inquiry of the chair first, Mr. Speaker.
State your inquiry.
Is this amendment going to be voted on right away? If the amendment's adopted by voice vote, are we going to vote on it right away? Is it going to be called for a vote right away?
On third reading, Representative Rebelletti?
Because we've seen some floor amendments come up, they've been adopted, and we've moved right to third reading.
This bill will not be called on third.
I'm going to ask for a roll call on the amendment, but I also want to ask questions of the sponsor.
State your questions to the sponsor.
Will the sponsor yield?
She indicates she will.
Representative, I know that you don't control the body here, but why wouldn't this go to a substantive committee first, Judiciary or Restorative Justice or any other committee, and then make its way here to the floor so there'll be some debate at a committee level before we come up to the House floor?
I don't know.
And is it your assessment that this is a May issue? So what would the conditions be in a May issue scenario? Is this tailored after what would be perceived as a New York state legislation?
Yes, it's very similar to New York.
And
there are statutory eligibility requirements, the establishment of a need, and a responsible person, and no criminal background, no other disqualifiers.
So if I wanted to apply for a concealed carry permit under this legislation, how would I go about doing it? What would make me qualify to be able to conceal and carry a firearm?
Depending on where you live, you would either submit it to your local sheriff, or if you're in the city of Chicago, to CPD, who would first establish the question of need, and then your background check would go to ISP.
Are there, in this amendment, is there a list of items, we'll call it a checklist of sorts, that this is what the qualifications would be for a certain condition? Maybe I'm a victim of a domestic battery and I need protection in that respect, or I've been stalked, or what are the conditions that would allow me to be certified for this May carry permit? What would my sheriff look at?
You would need to demonstrate a particularized need for the license, such as exposure to unusual personal danger distinct from that of other members of the community. There is not an exhaustive list that describes what those things would be, just as as I said in my opening, our communities are different. Since you're establishing danger distinct from other members of your community, it would be unique to your community.
Why is it that you're choosing the sheriff of each county to be the person that makes that determination? Why wouldn't it be the local police chief, the state's attorney, the attorney general? Why wouldn't it be somebody else? Why is it each sheriff? Because one of my concerns is that you're going to have 102 different sheriffs, and then then you have superintendent of the Chicago police, so you have 103 people being, I guess, very subjective as to what may qualify in Cook County or may not qualify in Cook, would qualify in Coles County. Are you concerned about this being very subjective and not uniformly applied across the state?
Local police are statutorily authorized to weigh in. The sheriff is the most consistent body across the state, and given the sheer volume in the city of Chicago, adding CPD in made the most sense.
Have you had an opportunity to talk to your sheriff? I haven't had a chance to talk to my sheriff about this, but I can't imagine that Sheriff Dart or Sheriff Saruba would have the resources to then process all this paperwork. Is there going to be funding? Is there going to be funding going to the sheriffs to process the paperwork and make the final determination?
A portion of the fee would be attributed to the sheriffs to administer it.
Do you have any idea how many more employees that the Cook County Sheriff would need to conduct this program?
Just like with prior versions, there are 6 months to implement in order to establish those needs.
And I appreciate that. I know that our sheriff wants to hire more deputies and put more on the street. I can't imagine that the superintendent of Chicago Police, I know the mayor of Chicago want to put more police on the street. I have a general concern, and I don't know if you share this, Representative, is that wouldn't this actually take police officers off the street to be doing paperwork and doing processing instead of being out dealing with the gangs and the drug dealers?
No, it would be. I believe it would be a separate department established with the funding from those fees.
What if is a sheriff subject to any type of lawsuits then, based on the fact if I'm denied a permit, what is my appeals process? Do I appeal to a circuit court? Where do I go to appeal if it's a denial?
Just as under the FOID card, the appeals process goes through the state police.
And how do I file? What would I file with the state police? Is there a motion I would file? I mean, where do I go to District 5, depending where I live?
There'd be an
District 15?
administrative hearing subject to judicial review.
where would those administrative hearings be held? In Chicago, Springfield?
I think that would depend on your location, established by the department. And again, we have 6 months in order to work that out.
No, and I appreciate that, but in some of the rural areas, I don't know where the hearings would be. So I don't know if it's going to be Carbondale, Chicago, and Springfield. People may have to travel 100 miles to get to a hearing. Is that
Once again, we would have 6 months to establish the best practice that's going to serve people in the most appropriate way. And it's the same practice that we have under the FOID Act now.
Once an application is filed with the sheriff, how long do they have to render their decision?
The sheriff has 30 days, and the state police has 90 after the local decision.
So basically, the sheriff is signing off on it, but the final approval comes from the Illinois State Police?
The sheriff is signing off on the distinct need. Yes.
What makes the sheriff qualified to make that determination versus anybody else? I know that you keep going back to it, I know that New York does it, but what makes the sheriff that individual that we would put all the trust into? Not that I don't trust the sheriffs. What makes them that entity that makes the final determination?
In each community, the sheriff is going to have the best understanding of the questions of personal safety in their community.
Is this an end around to keep Cook County into a may issue, and then everybody else would be more of a shall, so downstate would probably be more liberal with their concealed carry permits versus Chicago and Cook County could basically deny every permit? Is that really what this is?
As I said, what this will allow is for us to acknowledge that our state contains many different cultures, many different communities with different needs, different characters, and does not require a one-size-fits-all approach.
And we're still waiting to become the 50th state to have conceal and carry, and other states have done it. Don't you agree, Representative, that this is not consistent with the Seventh Circuit's decision in the appellate court, that this should be a shall issue, not a may issue?
The Seventh Circuit did not specifically say that we needed to have a shall issue. 4 other appellate courts have upheld may issue, and the Supreme Court recently denied cert in the challenge to the New York law, and I think that sends a good message that we have a good opportunity here to find a solution that will work for all of us.
I guess, Representative, that's where you and I would disagree, because I believe that the Seventh Circuit said it's a shall issue and not a may issue. I'm going to listen to some of what other speakers have to say about this, but I believe this is really just an end around what the Seventh Circuit has stated we should do by June 8th or June 9th. I think we're going to find ourselves right back in the same trick bag. We'll be right back to constitutional carry. I would anticipate additional lawsuits will occur, and we'll be no further ahead. So I'm going to, at least at this time, urge a no vote.
The chair recognizes Representative David Harris.
Thank you, Mr. Speaker. Question of the sponsor.
State your question.
Representative, forgive me, I was in the men's room for a brief period of time, and then when I came out on the floor, there was a lot of noise related to the passage of the bill that just went out, House Bill 1. So help me understand, is this legislation, is this in effect, well, it deals with concealed carry, correct?
Yes, it does.
And is this in effect a legislation which authorizes may issue versus shall issue?
Yes, it is fair to describe this as a may issue bill.
And this legislation then is no longer being considered in special orders of business. Is that correct? We're through with special orders of business. You might not know the answer, but you can ask the person maybe sitting to your right there.
That would not be my call.
I see. So we're not doing special orders of business. This one just pops up on its own. But when we were doing special orders of business, didn't we have a may issue amendment to the bill that we were considering under the special orders of business?
It was never debated.
Oh, it was there, but it was never debated.
Yes.
I see. Okay. And the individual, do you know what the gentleman who sponsored the concealed carry legislation for Illinois, I believe the number was House Bill 997. Do you know how he feels about the may issue or shall issue?
I imagine he'll let us know soon.
He'll let us know soon. Okay. That's very helpful. So we're talking here, this amendment is a may issue amendment law versus shall issue. So I have that straight, right?
Yes.
Thank you very much.
The chair recognizes Representative Phelps.
Thank you, Mr. Speaker. And to the amendment, Representative Harris, here we go. And I hope everybody listens to this because these could be historic. And congratulations to Representative Lang. I think I would like to have that same treatment once I run my 997, hopefully. But there's a lot of bad things going on with this bill, and I know this is just the amendment, but we want to try to kill this right now. Here it is. This is not only a May issue, this is a double May issue. This is a double May issue. It's a May issue on the local level, and holy moly, it's a May issue on the state level. You're talking about sheriffs being able to get these permits and issue these permits. Well, the Illinois Sheriff's Association is totally against this. And let the record reflect, most of law enforcement is against this bill. Therefore, our version of the concealed carry bill. Now, here's another thing. If you remember, a previous governor talked about he wanted $500 for a FOID card. Do you remember that, Representative Bost? Page 10, paragraph H. Fees are set by rule. These are unlimited fees. Now, you can't tell me the leaders that be in this state and in up in Chicago, in Cook County, they're going to try to jack this price up as much as they can. This could potentially be a $1,000 permit because it's set by rule. They don't want this. We don't want this. Let's wait. Let's kill this. Let's get back on 997 where it makes sense and what the court says. I urge a no vote.
The chair recognizes Representative Sullivan.
Thank you, Mr. Speaker. To the bill. Ladies and gentlemen, today is the day. Today you get to start to finally enact legislation that will cover the citizens of our state. A lot has been said, but I do want to have a couple things to look at. Within this legislation is embedded a couple things. First off, give me 2 seconds. Beyond who can issue the license, it also says you have to have a particular need for the license. And I ask you, when your life is in danger, when do you have a particular need? So we're going to start defining winners and losers within this licensure on whether you're safe or not safe. That is fundamentally flawed within our Constitution, and so this will be thrown out for that very reason. I believe it was said that the Sheriff's Association is in support of this bill. The Sheriff's Association is not in support of this bill. They do not want to be issuing these things on a sporadic basis, and that's what this exactly will do. Do you want your family members to be investigated? Because under this legislation, well, you have to go through certain checks. It gives the state police authorization to look at your family members. Do you want to put them through the harassment for you to be able to have a concealed carry permit? I don't think that's what we want to do or should be doing. Ladies and gentlemen, the previous speaker talked about the fees. The next bill you will see will be the good bill, and we have fees that are reasonable. We have come a long way on the fees to take care of the state police for mental health records that all of us want. We don't know what the fees are going to be here. Are they going to be $500, $1,000? We don't know. And lastly, there's wording within this legislation that the state police say we don't have to implement it till all of our concerns have been satisfied. Well, what would those concerns be? Do we want to have such broad language that says all of our concerns have been satisfied? Ladies and gentlemen, I believe this is an unconstitutional bill. We do not want to go to June 9th and not have any type of protections for concealed carry. That's what this bill will do. Today's the day. You have another bill coming. I advise everybody to vote no. Thank you.
The chair recognizes Representative Bost.
Thank you, Mr. Speaker. Will the sponsor yield?
She indicates she will.
Do you feel like this is a substantive piece of legislation? It really does have some, I mean, quite a bit of language in it, correct?
Yes.
Then why in the world is it a floor amendment? Why in the world did it not go back to committee? Let me tell you that, and the leader's going to tell you, I voted for this out of rules because I didn't realize it. My goodness, you know, that was my mistake. That sometimes rules committee moves very quickly. My gosh, people, don't you think that the people of the state of Illinois are tired of seeing something like this? We have rules, and yet you bring something that should be just a floor amendment. Floor amendment should be some technical, small change that we didn't have to worry about like this. But yet you bring a whole bill that has questions whether it is even constitutional, that has questions whether it meets the court's approval of what we're trying to do with concealed carry. Folks, the process is really messed up. Quit. This is not the bill that everybody's debated, the bill that everyone has talked on, the bill that everybody wants to see out here. It is a ploy, and once again, your side of the aisle keeps trying to make ploys instead of dealing with the real issue. Keep playing games. Keep playing games. There is a time limit online. Do you know that one of the associations actually has a click down of when we have constitutional carry in the state of Illinois? And you want to endanger your citizens and keep playing games like this? Vote no.
The chair recognizes Representative Costello.
Thank you, Mr. Speaker. Will the sponsor yield?
She indicates she will.
Ladies and gentlemen, I don't know if anybody read Capitol Facts this morning, but something that was extremely important in there. If you look at the state of New York that has a May issue, 1/10 of 1% of their population gets a permit. Is that true, or do you know, Representative?
I have not looked into how many people get it in New York. I stopped reading at Rabid Gun Grabber.
Okay, well, when I look at it and I look at what is a constitutional amendment, constitutionally you have the right to bear arms. What if we had a situation when we're talking about the 15th Amendment, another constitutional amendment, if 1/10 of 1% of people were allowed to vote? We're talking about the Second Amendment, the right to bear arms, and we're talking about in many situations in the state of New York, you get people who are athletes, you get people who are politicians, who are afforded this opportunity, and the regular people of the state are not afforded this opportunity. We don't need bureaucrats issuing these permits to their friends and people as such, in my personal opinion, Representative.
This model has been upheld by 4 appellate courts, and this specifically addresses folks who can establish a need for personal self-defense.
And I go to the fact that it's 1/10 of 1% again. That's troubling. That's extremely troubling to me. This bill is too vague. There are many, many things, in my opinion, intentionally left out of this bill. Talking about the fee, do we want to make your Second Amendment rights a socioeconomic situation? We want to have a situation to where you could charge $1,000, $5,000, $10,000 for this permit.
Representative, the language in the bill very clearly states the fees are limited to the administrative and enforcement costs, which are going to vary by the geography of the county in question. And so they cannot be set in any other way. But they are limited to established costs for administering and enforcing the law.
Do we have an estimate of roughly what those costs may be?
I'm going to go back to that 6-month period. We have to work that out.
So the answer is no.
No. And it will vary by county.
I believe this is a very, very vague bill. The one thing that gets lost in these discussions at times, again, ladies and gentlemen, in my opinion, we're talking about your constitutional right to bear arms. I urge a no vote.
The chair recognizes Majority Leader Curry.
Thank you, Speaker. Members of the House, I rise in strong support of the amendment. This discussion about shall and may strikes me as something of a grammatical quagmire. Under the NRA-approved bill, you can't issue a concealed carry permit to somebody who's under the age of 21, who doesn't have a FOID card, someone who has a prior conviction for a felony, a violent crime, a drug crime, a crime involving the unlawful use or delivery of a firearm. There is no shall carry in the bill approved by the NRA. There is discretion in other states that have concealed carry laws, and today the New York law, the California law are all upheld by the court system as constitutional. In the Seventh Circuit opinion that said that our law should be struck down, our law that allows no opportunity for public carrying of guns, the court said that it was legitimate for us to impose a balancing act to set the rights of people to be safe from guns that are out of control against the rights of people to be able to protect themselves. I think Amendment 1 to House Bill 831 does exactly that. It says no to guns, concealed guns, in places where there are large numbers of people, bars, theaters, arenas. It says that people should be safe in those territories, and it says that law enforcement should be able to make a determination whether there is a good reason for someone to have a concealed carry permit. If you want Illinois to be the Wild West, I invite you to vote against Amendment 1 to House Bill 831, but if you care about the safety and the health of your people, the safety and health of your people, not to be victims of violence out of control, the only responsible vote is yes.
The chair recognizes Representative Christian Mitchell.
Thank you, Mr. Speaker. Will the sponsor yield?
She indicates she will.
Representative Cassidy, is there precedent for may issue in case law?
There is. There have been 4 appellate court rulings upholding may issue.
Thank you, Representative. To the amendment, we are acting in this discussion as if somehow there has been a one-sided decision by the courts that binds us to do this only in the way that folks who are supportive of shall issue want it to be done. But let's be clear. In the Second Circuit in New York, they justified heightened regulation of firearms outside the home because public safety interests often outweigh individual interests in self-defense. There have been multiple cases where we have noted that the core value of the Second Amendment right is not necessarily something that allows us to ignore public safety interests. That there needs to be a proper balance between assuring access to handguns for those in need while preventing a proliferation of handguns in public that increase the risk to public safety. This is in case law. And let's be clear, nobody is saying that we're trying to take away guns from those who would like to have them. There's a different need downstate. There's a different need south of I-80. There's a different need in rural areas than there is in the city of Chicago. And respecting regional balance, respecting local control, as so many people want to do in every other aspect except this one, is extremely important because the city of Chicago and other urban areas have very different needs than downstate. We have a serious gun violence problem, and we need to make sure that we have the tools locally to address it as local law enforcement and local communities know how. I urge an aye vote on this amendment.
The chair recognizes Representative Drury.
Thank you, Mr. Speaker. To the amendment.
To the amendment.
You know, there's been a lot of talk in this room about the Constitution and what's constitutional, but the last time I looked around, there's not one single constitutional scholar sitting in this chamber. So why don't we stop with all the nonsense and talking about what's constitutional and what's not constitutional and get to what's actually in the bill and about what our Supreme Court, the actual scholars, have said. And it was just in the last week that the New York law was up in front of the Supreme Court of the United States, and the Supreme Court of the United States had the chance to take the NRA's appeal of the Second Circuit's opinion upholding may issue. And you know what the Supreme Court did? The Supreme Court decided not to hear the case because they were fine with the Second Circuit's opinion upholding may issue. That is the only opinion we have on the books from constitutional scholars. The Supreme Court declined to hear the case. So all of this nonsense, and it's absolute nonsense and two-facedness from the other side of the aisle, and I don't say this lightly, it's nonsense. It's nonsense, sir. It's nonsense. It is absolute nonsense. You know, you can scream all you want.
The House will be in order.
But
the House will be in order. The House will be in order. Representative Bost, you're not recognized. You are not recognized. Well, and you will not disrespect the chair either. Well, can you please? You do not have the floor. You do not have the floor. And Representative Drury does have the floor. I would not allow that if someone was doing it to you, and I would not allow you doing it to him. Representative Drury.
Thank you. So here's my point, members. We don't want someone like that carrying a concealed weapon.
The House will be in order. The House will be in order. The House will be in order. The next thing that I will say is I will call the doorkeepers. The House will be in order. The House will be in order. Representative Drury, I would wish that you would give your testimony, but give it in such a way that you are respectful to everyone in this House.
I appreciate that.
Please proceed.
The Supreme Court of the United States took this issue up last week. They declined to hear the Seventh Circuit's opinion upholding May issue. That is the law of our land, as it is right now. This is a good bill. It is a bill that is fair for everybody around this state. It is a bill that will keep us safe. It is a bill that deserves our aye vote. Thank you.
The chair recognizes Representative Sesha.
Thank you, Mr. Speaker. To the bill.
Bill.
Ladies
Amendment.
and gentlemen, I'm sorry. Ladies and gentlemen, this amendment is initiative of the Illinois Council Against Handgun Violence. I get that. It's opposed by the National Rifle Association. This entire debate over guns, as tragic as the issue was in Boston on Monday, it verified that guns don't kill people, crazy people kill people. It's what happened in Oklahoma City with fertilizer and fuel oil. It's what happened on 9/11 with box cutters and airplanes. Ladies and gentlemen, it's time we understood that guns don't kill people. And if Chicago has a problem with handgun violence, then Chicago should handle it.
The chair recognizes Representative Revelletti.
Mr. Speaker, I appreciate what you're trying to do, keeping this chamber in order. This is obviously a very emotional issue.
That Representative Revelletti, I really respect that, but then there is an issue of decorum on frankly both sides of the aisle.
And I understand that, Mr. Speaker. And what happens in these emotional debates is when we wait to the last second to try to pass these things, and then it becomes personal, unnecessary in this chamber, that anybody who just talked about who's constitutional scholars and who should decide who should carry firearms has just elevated themselves to chief in charge around this place. Those comments have no place in this chamber. If you don't like the legislation, don't vote for it. If you love it, put your name on it and speak for it. I don't understand what qualifies somebody to be a constitutional scholar or not, but I have a law license, Representative. I know how to look and brief a case and try to interpret what the court said so I can make the correct decision for my constituents, as well as something that complies with the United States Constitution and the Illinois State Constitution. And to a previous speaker about regional differences, let me opine about constitutionality and something called equal protection of law. There might be regional differences, but no citizen in this state should be treated any differently when it comes to protecting themselves if they're in Cairo or Carbondale or Chicago or Carpentersville. But some on the other side would say that's how it should be. There are regional differences, and we need to respect that when it comes to this. In this particular issue, it's about the Constitution, and we should all respect that. This is a retread bill. And it's not the Wild West, as another previous speaker said. If you go to the north to Wisconsin, it's the Wild North. And people are going to travel there for summer vacation. They're not going to be, oh, I won't go up there anymore because I'm afraid they have concealed carry. We'll go to the east to Indiana. They have concealed carry. I just visited relatives there over the weekend. I took my 11-year-old. I didn't say, oh, my God, they have concealed carry. I can't go over there because only Illinois is safe. Or to the west in Iowa and Missouri, or to Kentucky in the south. But we're right back where we were 6 weeks ago. It's time to pass something that comports with what the Seventh Circuit said. And I am entitled to what my opinion of that is. I don't need a lecture from somebody else to tell me what I think something is constitutional or not. I'm not a constitutional scholar, but I've spent 15 years with a law license in this state, which gives me some opportunity to discuss it with some semblance of professionalism and understanding of what the ruling means. I don't know why we had to go personal and tell somebody because they're passionate about an issue, they shouldn't carry a firearm. And to the people in the city of Chicago, those murder rates continue to go up. And the people of the city of Chicago are still not allowed to carry a firearm. And now they can go beg Sheriff Dart for a permit. And 60 days later, 90 days later, 120 days later, they'll be denied. And what's going to happen? Where will the outcry be when one of those people that applied for a permit is killed? What will happen then? We'll go to the Illinois State Police and say, you guys made a mistake? I have a great deal of respect for the sponsor, and I appreciate what she's trying to do, but this does not comport with the constitutionality. This should be debated on the merits of this amendment, up or down. It should not be made personal by anybody on this floor. There's no room for that garbage here.
Representative Cassidy to close on the amendment.
Thank you, Mr. Speaker. To the previous speaker, I share that respect, and I enjoy working with you, finding solutions, and you and I have been able to find common ground on a great many things that we began very far apart on, and I'm hopeful that on this issue we can work on that too. And I agree that we need to stay out of the personal. To the question of us being the last ones, I remember very clearly my mother saying it, and now as a mother I say it. If everyone else jumped off a cliff, would you have to do it too? We can do this in a way that works for us. We can do this in a way that has been upheld by the Supreme Court. We can do this in a way that recognizes that in my community, whether I have a gun or not is not going to stop the bullet coming through my window. It's not going to stop the bullet that hits a kid sitting on the porch. More guns are not the answer to the city's gun violence problem. To the question of double may that was raised earlier, both local law enforcement and state law enforcement have access to different information. It is important that all the information be utilized to determine the issuance of these licenses. The FOID records are not currently up to date. The delay is in there in order to make sure that all the appropriate information is available. When someone makes an application, we need to evaluate that application with accurate information in a timely fashion. This is an amendment that recognizes who we are as a state, what our communities are like, and acknowledges the deadline that we are operating under. It is far from the last minute. It is timely, It is fair. It is appropriate. I urge an aye vote.
Representative Cassidy moves do adopt floor amendment number 1 to House Bill 831. There's been a request for a record vote on this amendment. So members, vote your own switches. All those in favor of amendment number 1, vote aye. All those opposed, vote nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Please vote your switches. To Patty. Rita. Mr. Clerk, take the record. On this record, with 31 voting yea, 76 voting nay, 6 voting present, floor amendment number 1 to House Bill 831 is hereby declared lost. Representative Boss, for what reason do you rise?
For a point of personal privilege.
Your point.
First off, apology to you, Mr. Speaker, as a person, and to you as a chair.
Apology accepted, Representative Boss. We're good friends, as you know.
Mr. Speaker, we've always worked well together. But let me also follow up by saying there is never a time that by the use of our First Amendment rights, we should be not denied our Second Amendment rights.
Thank you. House Bill 1773. House Bill 1773, Representative Sesha. Mr. Clerk, read the bill.
House Bill 1773, a bill for not concerning civil law, third reading this House bill.
Representative Sesha.
Thank you, Mr. Speaker. Ladies and gentlemen, unlike much of the legislation today, this is basically a simple technical amendment wherein there is a common interest community association that, could I have some order, Mr. Speaker? If there is a common interest community association, it cannot enter into a contract with a member of that association. That's all this does, and I welcome any questions.
And the chair recognizes Representative Franks.
Thank you, Mr. Speaker. Will the sponsor yield?
In the case he will.
I'm looking at the analysis, Mr. Sesha, and my understanding is you can't enter into a contract with a current board member if that board member or his or her immediate family member has a 25% or more interest.
You know, interestingly, Representative Franks, our analysis on my side of the aisle is incorrect. The analysis is. But it's any amount, 25% notwithstanding. But on my side of the analysis, it says a member of an association with a member of the association. It's supposed to say let me read it. The Common Interest Community Association cannot have a contract with a member of that association. That's all this does. It changes 3 words in the bill.
I'm looking at the bill itself. That's line 9 as I pulled it up.
Yes, sir.
And it says it took out a member of the board.
That's correct, sir.
But it would still allow, then, family members, correct?
I guess the best way I can answer that, Representative Franks, is Representative Neckritz, the chairperson of the committee, worked with us on this, and she's very knowledgeable of this type of law. And she was in complete agreement of our amendment number 3. And when you ask the question if it could involve a family member, I can't deny that. Perhaps it could. But I know that the association cannot have a contract with a member of that association.
And amendment number 3 became the bill, as I recall.
That's correct, sir.
Okay. But this is still a gaping loophole. Why would we say that a member can't have a contract, but the spouse of the member could?
Representative Franks, I guess the only thing I can do is what you would want me to do, is pull it out of the record, as much as I hate to, because we went through a lot of negotiations with Representative Nekritz. If she's in the chamber, maybe she'd be willing to comment on it, and I don't see her.
I don't know, Jim, and this is the first time seeing it, but as I'm reading it, I know that you're a good government type, and I don't think that you would, on purpose, leave a loophole.
I certainly wouldn't.
So if you leave it in, I'm going to vote against it and encourage people to, because I don't think the bill does probably what you want it to do the way it's drafted. I would ask you to take it out of the record if you'd like to work on it with the Representative Nekritz.
Representative Franks, whenever you've asked me to take anything out of the record, I've done it. We've really worked hard on this. We went through 3 amendments. The first 2 amendments, Representative Nekritz wouldn't even allow us to call because she said they literally did not meet the criteria that she felt was required. I believe now we're to a point where we have a good piece of legislation. I understand where you're coming from. I truly do. But I am going to ask the bill to move.
Okay. Well, it's into the bill, and I appreciate it, and I know your intentions are good. I just don't like the way the bill's written, and maybe, I don't know, maybe the representative can answer this, but the way it's written now, I don't think it's in our best public policy to allow these type of contracts to be had by spouses and family members of board members. So I would encourage a no vote.
There being no further debate, Representative Stacia to close.
I appreciate that, Representative Franks. I truly do. And Representative Nekritz is now in the chamber. If she feels she can impart anything to this that makes it clearer, I would welcome that. If not, I would ask for your aye vote.
Seeing no further debate, the question is, shall House Bill 1773 pass? All those in favor vote by saying aye. All those opposed, nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Zaleski, Williams, Rice. Marcus Evans. Mr. Clerk, take the record. On this question, with 116 voting yea, 1 voting nay, none voting present, and this bill having received the constitutional majority, is hereby declared passed. Representative Drury, for what reason do you rise?
Point of personal privilege, Mr. Speaker.
Your point.
Mr. Speaker, I'd like to apologize to the chair and to the members of this House to the extent that my remarks were taken as being a personal attack. It wasn't the intent. This certainly was a very heated issue, and we speak passionately. I think the sponsor had a good bill, but certainly don't want that to get in the way of the important work that we have to do. I have the utmost respect for this chamber and just want everybody to know that.
Thank you, Representative. Next bill for your consideration is House Bill 374. House Bill 374, Representative Martino. Mr. Clerk, read the bill.
House Bill 374, Bill for not concerning finance, third reading this House Bill.
The record. House Bill 1571. Representative Lang. Mr. Clerk, read the bill.
House Bill 1571, a bill for not concerning regulation, third reading this House Bill.
Leader Lang.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, this bill simply allows insurance companies to purchase bonds issued by foreign countries. There's provisions in here from the Department of Insurance so that we make sure that they're qualified bonds under various circumstances. I know of no opposition to this bill, and I would ask your support.
The chair recognizes Representative Will Davis.
Thank you, Mr. Speaker. The sponsor yield.
He indicates he will.
Representative, in your description, you said that this will allow insurance companies to purchase bonds from foreign countries, correct?
That's correct, sir.
Is there any provisions in there that would prevent them from buying bonds from countries like North Korea? Any of those countries that we are having challenges with?
As far as we can tell, the only two countries that would qualify the way the bill is written is Israel and Canada.
Fair enough. Thank you very much.
There being no further debate, Representative Lang to close.
Please vote aye.
The question is, shall House Bill 1571 pass? All those in favor vote aye. Opposed vote nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Vote your switches. Hammond, Eunice. Mr. Clerk, take the record. On this question, with 118 voting yea, 0 voting nay, 0 voting present, this bill having received the constitutional majority is hereby declared passed. House Bill 827, House Bill 827, Representative Moylan. Mr. Clerk, read the bill.
House Bill 827, a bill for enacting criminal law, third reading this House bill.
Representative Moylan.
Yes, sir. Thank you, Mr. Leader. This amendment, this bill states that it's the witness statement issue that a victim has the right to have the witness statement issued into the record. And I ask for an aye vote. This was agreed upon by the state's attorneys, Illinois Attorney General's Office, and the Cook County State's Attorney.
The chair recognizes Representative Rebelletti.
Will the sponsor yield?
He indicates he will.
Representative Moylan, I asked you some questions about this bill in judiciary, and I'm trying to figure out why this is necessary.
Because it was under our impression that the victim has a right to have family members issue their statements before sentencing.
The victims already have a right to issue statements. It's already codified. So what is this changing? What is this doing differently?
Well, this makes sure that the prosecutor notifies the victim that they have the right to have people that were impacted, the family members that were impacted by the crime, issue statements how the crime affected them in a pre-sentencing issue.
Does this apply to misdemeanors and felonies? Because there's not pre-sentence reports usually in misdemeanors.
No, it's under my impression that's violent crimes.
There are violent crimes under misdemeanor cases such as criminal sexual abuse, domestic battery, aggravated assault. Does this apply to that?
I'm not sure, but when we were in committee, that wasn't brought up, Mr. Representative.
And you say this, it's the state's attorney's obligation to inform the victim. When is that notice supposed to be given? As soon as the case is filed?